Let me ask you a question. If the North Carolina Real Estate Commission audited your trust account tomorrow morning, could you confidently hand over your records knowing everything is perfect? Most brokers I speak with believe the answer is a resounding yes. And most of them, unfortunately, are wrong. In 2026, trust account audits are one of the fastest ways for the North Carolina Real Estate Commission to suspend or revoke real estate licenses, often without any allegation of fraud or bad intent. Today, I'm going to explain why trust accounts have become the Commission's primary enforcement tool and what every North Carolina broker needs to understand before an audit turns into a disciplinary case. My name is Nick Dogle, and I'm the owner and founder of North State Law in Raleigh, North Carolina. Our firm focuses on defending and protecting professional licenses across North Carolina, including real estate brokers who are facing audit investigations and disciplinary action by the North Carolina Real Estate Commission. So over the years, I've noticed a pattern. We've done a lot of these cases over an extended period of time. And when brokers lose their licenses, it's rarely because they were dishonest people. It's because they underestimated how unforgiving trust account rules really are. So we're going to talk about what changed, why enforcement is increasing, and most importantly, how to protect yourself. Why is 2026 so different? Because the North Carolina Real Estate Commission has always regulated trust accounts, but this year marks a shift in how aggressively those rules are enforced. So from the Commission's perspective, trust accounts represent consumer money, and consumer money is where regulators apply a zero tolerance. The Commission has increased audit frequency, scope of record review, expectations for documentation, and a willingness to escalate audits into investigations. In other words, what may have been handled informally in the past is now more likely to result in formal discipline. Brokers who rely on outdated practices or assume that no harm, no foul still applies are putting their licenses at serious risk. So let's look at what a North Carolina Real Estate Commission audit really examines. So a lot of brokers think an audit is really just a simple math check, right? And it's not. An audit examines whether you followed a process, not just whether numbers are eventually balancing. Auditors look at when funds were received, when they were deposited, where they were deposited, who authorized disbursements, whether reconciliations were timely and complete, and whether records can be produced quickly and clearly. So even if a client lost no money at all, a process failure can still be a rule violation. And once the Commission identifies one violation, they often start looking for patterns. So the most dangerous assumption that we see brokers make is this. They say, quote, if there's a problem, I'll just fix it. And while that mindset is great that you want to fix the issue, that can also destroy your defense. Reason being is once the North Carolina Real Estate Commission initiates an audit or investigation, changing records can be interpreted as falsification or concealment. What could have been addressed as a compliance issue suddenly becomes an integrity issue, which is why you must be careful when you get your trust account into compliance. Let's look at some of the most common audit triggers and what aren't so obvious. Those include delayed deposits caused by weekends or holidays, multiple transactions moving through one trust account without clear labeling. Also, you'll have delegating trust account duties without oversight, relying entirely on software without manual review, poor communication between brokers and administrative staff. And the Commission really doesn't care who made the mistake at the end of the day, because the licensed broker, from their perspective, is ultimately responsible. So if your systems rely on trust rather than verification, an audit is going to expose that. So in 2026, brokers need to stop thinking about trust accounts as an administrative task and really start thinking about them as a compliance system, because that's what it really is. It's a whole system. There needs to be policies and procedures about this. And that gets into some of the main points that I want to make. I mentioned the written procedures. You also have to have consistent timelines. You also need to do monthly internal reviews, clear separation between operating and trust funds, immediate escalation of any discrepancies. Also, three-way trust reconciliations at the end of each month is super important. And most importantly, you need to understand when you need to not respond alone. If the North Carolina Real Estate Commission contacts you, how you respond matters just as much as what's in your records. Early legal guidance can often limit the scope of an audit, prevent misstatements, preserve defenses and reduce disciplinary exposure, and waiting until charges are filed is often too late. So here's what I want you to take away from this. In 2026, your trust account is not just part of your business, it is the most vulnerable part of your license. The North Carolina Real Estate Commission is using audits as primary enforcement tools, and many good brokers are caught off guard by how strict the process really is. If you want more videos regarding your real estate license and professional license defense in North Carolina, be sure to like and subscribe. Thank you so much for taking the time to watch our video, and I hope everybody has a fantastic day. Bye-bye.